Hi, this is Cora Stack again, Dr. Stack. I just wanted to, there was one other thing that I wanted to discuss here, and it's something that's fascinating, and it's critical to the case here, and it's like another thing that has sort of wowed me in terms of concept, and it's called the balance of convenience. So let me try and explain this, because I know there's a couple of law students and not interested people interested in law watching this. So it's to me it's fascinating. So it has to be fascinating for legal people, and I know there's a few there. So how courts weigh justice in urgent case. Now this is critical to our case, so it's not just it's something that wowed me as a concept. So, but it was actually also critical. So. When a case is urgent, when the stakes are high and a decision can't wait, the courts turn to one crucial principle called the balance of convenience. It's the legal tightrope that decides whether justice should pause or proceed. My name is Dr. Cora M, and today we're unpacking what the balance of convenience really means and how it shapes constitutional, democratic, and human outcomes. So there's a lot of stuff going on here. I like this shapes constitutional, democratic, and human outcomes. I like those three kind of on the, three kind of in part of the triangle. So what is the balance of convenience? In Irish law, following two case laws, interestingly enough, so this is from the common law, it's from the common law, which is from the judiciary side of things, following Campus Oil, and refined by Okunade versus the Minister of Justice. The balance of convenience decides whether the court should pause something temporarily while a full case is being decided. The idea is simple but powerful. Should we stop something now to prevent irreversible harm, or let it continue, trusting we can fix it later? So it's incredible. Like this is the common law is divided into or not the law is divided into the government, if you like, the executive, laws made by the executive, and laws made by the judiciary, and their kind of separation of powers, and then the kind of president kind of goes between them and that sort of thing. So because he has the right to refer all laws to the Supreme Court for just for oversight and testing and so on. Is there a series? So the three aspects to this that have to be that have to be tested are: is there a subject to the balance, the balance of, the excessive, civil law balance, excess of 50% or probability of 0.5? Is there a serious issue to be tried? That's the first thing that has to be tested. Secondly, what would damages be adequate? That's a tricky one. And where does the balance of convenience lie? So they're the issues that. They're the issues, but the third one is the one that really interests me. The heart of the argument. Let's imagine a constitutional case, say something we're in at the moment, a contested election process. On one side, the applicant argues that the election could breach constitutional law, which is essentially what we're talking about, particularly both we're talking about, both because of the issue with the protective disclosure. See, that's the dimension that a lot of people don't understand. That's why I've been trying to explain that, because that's new. That's very new, you see. On the other side, that's new insights is that I've, I'm copywriting myself since I'm the first person to find it. On the other side, the state insists stopping it would be inconvenient or disruptive. That's their particular right. The court must weigh these two sides: irreparable harm versus administrative inconvenience. So applicants' factors, for example, we might be saying constitutional integrity, our legal way could be very strong. Irreparable harm, overwhelming, because we might be saying that the current protective disclosures as amended would be unconstitutional, and in terms of in compliance with current EU legislation. So that's EU law. This is the point. EU law supremacy reinforces suspension, public confidence, strong constitutional good. The state factors could be timetable inconvenience. Well, that's the legal weight, is that whatever weight is given to that. Administrative disruption, Well, would it be marginal if it wasn't very long? Judicial restraint balanced by duty to vindicate rights. So that's a big one for them. Balanced by duty to vindicate rights. So that would be a big one for them. The EU and constitutional dimension. The European Court of Justice. This is a point here I think was very important with our evidence with regard to the Protective Disclosures Amendment Act and looking at it in terms of its legality at the moment, as amended. And I've spent a lot of time talking about that. But the European Court of Justice has made it clear in Factore Mani and Cimental and another case that national courts must protect EU rights even at the interim stage. In other words, legality cannot be sacrificed for convenience. So when election or government decision risks breaching EU law or constitutional principles, which we believe the current Amendment Act does, Act as amended does, a temporary pause isn't interference, it's actually protection. Strategic outcome. So for example, a possible outcome, which could be, we've no say in this whatsoever, but like just looking at the facts now, as we're looking at it now, as we're refining it down here, and looking at the problem really is this business with this amended, this amended act, which, as I say, what it did to it kind of twisted illegality into legality, which is mind-blowing by this commissioner's role, etc., or what he was not allowed to do, or what he was allowed to do. So a well-defined pause, say, 25 to 40 days, something like that, doesn't derail democracy, it preserves it. The 60 days are allowed under the Constitution, I think, because that's allowed, it preserves it. It gives space to ensure fairness and legality before irreversible harm is done. We might be saying maybe 60 days there. In this context, the inconvenience to the state is largely procedural, but the harm to democracy ignored could be permanent, particularly if a law is unconstitutional and isn't EU compliant. So that's really where we feel where our strength is. But that's not a matter for us. It's trying to explain it being a lay litigant. When you're not. It's very difficult. I mean, have you equality on the law? Should you have? This is very, very difficult in such a short time. So conclusion: justice and balance. So when we speak of the balance of convenience, we're really talking about the balance of justice. It's the court's moral compass ensuring that law, rights and democracy hold steady in moments of uncertainty. Because sometimes the bravest thing a court can do is pause. So that's the balance of convenience issue by Dr. Cora M, Stack PhD, myself, pure mathematics, 225 Ramaj, and he was a memorial. It's a memory of him. He was a physics Nobel Prize laureate from India. Memorial Award for Excellence in Academic Leadership and Visionary Leadership and Excellence in Academia and Education. So that's just a little quick overview of something that's been fascinating me for the last few days, and that is the balance of convenience.